When the average person hears the words residential burglary, they immediately picture an armed intruder in a mask breaking into a bedroom to terrorize a family. But in 20 years of defending these cases, I can tell you that Hollywood version is almost never the reality. Most of the cases I see in California courtrooms are a byproduct of drug addiction, poverty, untreated mental health crisis, or simple opportunistic mistakes. We're talking about someone seeing an open garage and grabbing a bike for quick cash, or someone walking into a home completely drunk or in a state of total confusion. But here's the trap. The district attorney does not care if you were desperate, high, or if you thought this was an empty home. While some prosecutors are going to use their discretion appropriately, many choose to file the worst possible charge they can. And if so, you could be looking at a life-altering strike conviction and a prison cell. Today, I'm going to break down how the system overcharges you and how you can fight back. My name is William Pernik. I'm a criminal defense attorney in the state of California and a state bar certified specialist in the field of criminal law. For the last 20 years, I've been in the trenches defending people against serious felonies. And I'm constantly fascinated by how the real world of the law is vastly different from what people imagine. I record videos on this channel in order to bridge that gap, to give you the facts so you can make decisions based on reality and not the fear-based narrative the police and the government want to write for you. In California, the crime of residential burglary is not just breaking and entering. That's the first mistake people make. The legal definition of a residential burglary is, number one, entering a residence with, number two, intent to steal or the intent to commit any felony inside. Because that definition of any felony intended to commit inside is so wide, so broad, the district attorney has an incredible amount of room to overcharge your case. In order to give you just a few extreme, real-world examples I've seen, consider the following. I've seen people facing a strike for stepping into an attached garage just to plug in a phone or grab a soda. I've seen really intoxicated people break into a neighbor's home because they couldn't find their own keys, only to be hit with a serious felony, residential burglary, because of the property they damaged inside, or food or liquor they may have consumed. In one case, I had a client looking at life in prison for walking into an open attached garage and grabbing a pair of $3 pruning shears. Life in prison for a $3 item. I want to be very clear with you. To the district attorney, your residential burglary crime is a big deal. It is a serious and sometimes violent felony and a strike they can use to leverage you forever if you ever get in trouble again. That's why they like it. To give you a better idea of how massive the stakes can be with this charge, consider the following. Residential burglary is a strike in the state of California, which means it is always a serious felony under California law, and one that could make you eligible for a life sentence if you have 2 or more prior serious or violent felony convictions. It is also sometimes a violent strike if somebody was present in the home when you entered. As a violent strike, it will require you to serve 85% of your time in prison. And the sentence for a residential burglary is really steep. We're looking at a possible sentence of 2, 4, or 6 years in state prison. If you happen to have a prior burglary on your record, they can tack on a 5-year enhancement. And if you have a prior strike, you could be looking at a sentence that's now doubled. That means you could be looking at a 17-year prison sentence for a single charge of residential burglary with a prior residential burglary conviction. In addition, getting probation is really difficult for a crime of residential burglary, unless your lawyer can prove that unusual circumstances exist to your judge. Fortunately, residential burglary convictions are not that easy to obtain. That is because to convict you, the government has to prove your specific criminal intent at the exact moment that you stepped inside the home. If the government cannot prove what was in your head, their case can entirely fall apart. I'm going to give you a sample of some of the successful defenses that top criminal lawyers in California use in these cases. Number one, no intent. If you entered into a residence with any intent other than to commit theft or a felony inside, it is not a burglary. Maybe you went in because you wanted to find a place to sleep. Maybe you went in because you went to hide from someone. Or maybe you went in because you thought it was a party. We need to identify the actual reason why you went in and find supporting information to prove it, because that's exactly how you can beat back the charge of residential burglary. Another defense that sometimes applies is the permission defense. This could be huge in domestic violence situations. I've tried cases to a verdict where a client used his old keys to enter a home he was kicked out from. by his spouse, only to get back his property. Even if a fight broke out later inside, if his intent was to get his stuff and not to commit a felony, it is not a residential burglary. In one of my favorite cases, my client was actually acquitted, and in shocking news, the couple actually got back together after the trial. This is also something that I have used in cases where people agreed to get together inside a home to party or use drugs, and someone came in as an invited guest only to be charged later by the police as a burglar after a fight broke out, something else happened, or a neighbor complained. Mistake of fact is also an excellent defense to the crime of residential burglary. If you honestly but mistakenly believed you were in your own home, or you had the right to be at the residence, the wrongful intent required for conviction is gone. Remember the drunken party example? If someone invited you to a home they had no right to be in, but you believed them, you didn't commit a burglary. You had mistakenly but reasonably believed that you were a guest, and therefore you did not commit any crime. Even if the real owner later informed the police, they have no idea who you are, and they have never seen you before in their life. Because residential burglary is a specific intent crime, intoxication and mental health issues play a huge role. If you were too intoxicated to know where you were, if you were too high on drugs, or you were going through a mental health episode, it is entirely possible that you could not form the specific criminal intent required for the charge of burglary. That means you did not commit that crime, though you might be looking at a lower level of offense of trespass, which is a misdemeanor. There is also a defense of necessity. In an extreme example, if you broke in to escape a life-threatening emergency, this could be a complete defense, particularly if you did not create the emergency and the harm you avoided is greater than the one you created by breaking in. I want to share something personal with you that hopefully can help you see this crime in a different light. Most people I defend on residential burglary charges typically aren't criminals. They're usually folks in crisis. Or sometimes these are people who made an honest mistake and now they face a really serious charge. To help separate the two and get our clients help, we developed a really useful technique that consists of 3 steps. First, we ask, what is the underlying why behind this incident? Was it a factual why, like entering the wrong home by mistake? Or is this a clinical why, like a mental health crisis or drug addiction? Knowing which way the defense is going helps us identify the best path forward early on. When we're dealing with a factual why, we deploy our investigator and build all of the support we need in order to persuasively tell your story to the court or to the jury. That means getting proof that would show why you would think that you had permission to be there, or how you mistook in a drunken state your neighbor's home for your own. If we're dealing with a clinical situation, which is very common, we use mental health professionals in order to diagnose the issues that you were having and to address them, either through drug or alcohol counseling or dedicated mental health treatment. We work with your treatment providers to develop a comprehensive treatment plan, and we make the push for treatment the center of our advocacy, all so that we can see if we can get you a dismissal or qualify you for alternatives, like mental health diversion. This last part isn't just about winning an argument in court. It's about proving to the court that you are not a threat. You are a person, a human being, someone who needs to get help so you can be healed and restored to being a good citizen and a productive member of our community. Once again, I recently received a message that reminded me why this matters. And it was a message from a former, real client of mine named Larry. When I met Larry almost 15 years ago, he was facing life in prison. Because of his prior record, the state of California saw him as a dangerous, recidivist criminal. His latest crime? Well, Larry was a heroin addict who, while totally wasted, high out of his mind, walked into an open garage that was attached to the residence and walked out with a $3 pair of pruning shears, which he didn't need. The district attorney wanted to lock Larry up forever, and they had a good reason for it. Larry had a long criminal record, and he had a number of convictions for residential burglary, on facts probably very similar to this one. But when I looked at the why behind Larry's crime, it was clear to me this wasn't the right thing to do. Where the district attorney saw a hardened recidivist, I saw a drug addict, somebody who was desperately sick and completely devoid of criminal intent in that moment. Now, this was before mental health diversion was even a law in California, but I used something very similar to the method I just described in order to convince a very conservative judge to give Larry one last chance. Instead of prison, Larry went to the Delancey Street program in San Francisco, which is an amazing place for recovery. He didn't just avoid a life sentence, he actually changed his entire life. He has been sober and crime-free for over a decade. And every once in a while, he still calls my office, just to let me know that he's still doing good. Today, we have even better tools than I had for Larry 15 years ago. And that's because over time, the state of California decided to create really important rehabilitative programs, like diversion. Depending on the county, different programs have been funded. But for purposes of this discussion today, I want to talk to you about two programs that are required and exist as a matter of state law. Mental health diversion under Section 1001.36. If a treatable condition like schizophrenia, bipolar disorder, or post-traumatic stress disorder, or drug-induced psychosis played a significant role in the commission of the offense, the court can divert your case into treatment. This is a really great option to avoid a conviction for a residential burglary charge if you entered a home in a state of mental crisis or psychosis, or if your underlying mental health disorder influenced and contributed to your criminal behavior in a less direct way. For example, consider a case I handled several years ago where my client was suffering from psychosis and ran into a home that wasn't his. He was delusional and paranoid and obviously scared the crap out of the residents when they found him in the home, using their clothes, eating their food, and acting like it was his own. Although my client was later charged with a residential burglary, he actually was eligible to get his case dismissed through diversion. Because number one, he had an eligible mental health diagnosis. Number two, his mental health disorder clearly played a significant role in a residential burglary by causing him to enter the home in a state of psychosis. His disorder was treatable, and he was willing to participate in a treatment program and would not pose an unreasonable risk to public safety if the court allowed him to be treated in the community. Diversion gets harder to obtain when the relationship between the crime and the mental disorder is less direct. This is where it really pays to have a good lawyer who understands mental health and addiction and how much certain conditions can affect a person's thinking and behavior. The law allows for mental health diversion, even where the condition does not directly cause, but merely contributes to or motivates the crime. But persuading your prosecutor or the judge to grant diversion when we're dealing with something like depression or anxiety or drug addiction alone to divert your strike, that's going to be much harder. It is a lot easier to convince the court to grant diversion in a case when you were hearing voices and the voices told you to go inside the home or take things from it. That's a more direct connection. For veterans and active duty military members suffering from service-related trauma, substance abuse, or any mental health condition, there is a very similar program called military diversion under Section 1001.80. The biggest benefit of this program is that treatment is done in a specialty court with other veterans and using VA's treatment team and supporting resources, which is tremendously helpful to veterans who go through a criminal case. The program for felony cases is very similar to mental health diversion for non-veterans, but the biggest benefit is that you're going to be doing it in an environment with other people just like you. Whether you do mental health diversion or military diversion, the biggest benefit to you is that a successful completion of diversion is going to lead to a full dismissal of your case, protecting your criminal record and your future. You no longer have to plead guilty to a charge in order to get diversion. And upon completion, your arrest record will be completely sealed. If you or your loved one is accused of residential burglary, follow this roadmap. Number one, stop talking to the police. The police officers are not your friends. They don't care about your side of the story, no matter what they tell you. Remorse is for the judge. Silence is for the cops. Anything you say to explain your intoxication or why you were there is only going to be used as evidence to convict you. So keep your mouth shut. It's going to help you a lot, I promise. Preserve evidence of any permission to be at the property. That means save your text messages, emails, or log code confirmations. If you had even a hint of a reason to believe that you were allowed to be there, that evidence is going to be key to proving that your intent to go inside was not criminal. Please remember, state of mind is a powerful defense. If you were in a mental health crisis, we can use experts to show the jury that you were not in any mental condition to plan a crime. If you were paranoid or delusional when you entered the home, most likely you couldn't form the intent the law requires. Beware of sales trap. If you sell door to door and the product you sell is a scam, the district attorney can actually charge you with a burglary just for stepping inside the home in order to sell it, even if you thought the job was legitimate. Be extremely careful with who you work for and what business you transact in someone else's home. Please be brutally honest with your lawyer. Don't hide a drug problem or mental health problem from them. We cannot apply our three-step method if we don't know the truth. Your struggle is the fuel for your defense. If you are a licensed professional or a non-citizen, please remember the charge of residential burglary can be a killer. A burglary conviction is considered a crime of moral turpitude, which means a flaw of moral character. It can end a professional license, a security clearance, or result in immediate deportation or loss of legal status. This isn't just a jail sentence issue, it is a life issue. So you have to be extremely vigilant. Residential burglary is a high-stakes charge, but stories like Larry's prove that there is a path back, even when you have a long record or the case looks really, really bad at start. You just need to have faith, hire a really good lawyer you trust, and listen to his or her advice. If you found this video helpful, hit that like button and subscribe to my channel. You might want to also check out my video on how to fight the charges of receiving or possessing stolen property. We drop new videos like this every week to help you navigate the system. So please leave a comment below if you have any questions, and I will try to jump in and answer as many as I can.